Again, hi everybody. Good morning. There she is. All right, our presenter has just joined us. Hey, Rebecca. So she had a
Thank
little Zoom difficulties when you don't send the link. So, all right, Rebecca, I'm making you co-host here.
you.
You should be able to have screen share abilities. And everyone, again, just good morning. I'm Monica Moore. I am the face behind the emails for our caregiver support groups at UCLA. It's nice to see some familiar faces and some faces to emails that I know. We have the great pleasure of having the phenomenal Rebecca Goldfarb come and speak to everybody today. She really is just a wealth of information when it comes to elder law and really taking care of your loved ones with Alzheimer's or other forms of dementia on a legal aspect. So Rebecca is absolutely lovely. And Rebecca, I'll let you do any other introduction that you feel necessary. And then I'm just going to sort of sit back and let you take over. So if anyone has questions, put them in the chat, and then I'll monitor that. And then Rebecca, do you want to take a look at that during the presentation? What's your preference here?
We're a relatively small group, so just people can pipe up when they have questions, because then it's in the moment. It will everybody probably has similar questions. It's just there's one brave soul who's willing to ask.
Excellent, great. So can you share your screen?
I'm going to, let's see, desktop 2.
Perfect.
And then I'm going to turn it into the presentation. Hold on, it'll get there.
And we did have 52 people who RSVP'd. So
wow.
I know some of those people obviously probably could not come, but they wanted the recording anyway. So we should be able to have a nice little viewing of this. So again, everyone feel free to interrupt Rebecca or put your questions in the chat. I'll monitor the everyone's little squares. So if you want to wave wildly, I'll pop in and see how we can get your questions answered. So Rebecca, the screen is yours.
Great. Can you see the intro slide? Is that what everybody sees?
Yes.
Okay, perfect. All right. So as Monica said, I'm Rebecca, and we exclusively practice estate planning and elder law. I know a tiny bit about tax law, a tiny bit about family law, and a tiny bit about property law. But for the most part, we stay in our lane with estate planning. It's just those have overlaps with estate planning and elder law. So I am happy to answer all of your questions today, and I'm going to go through my presentation. I have more to share with you than time allows, so I go pretty fast, but just stop me if you're like, what the hell did she just say? And I will repeat it 100%. Or try to explain it in a different way. And if you have questions where you aren't comfortable asking in front of the group, I understand that too. So just reach out to me, separately afterwards, and I'm happy to help you as much as I can. So my intro into estate planning is that Din, my best friend and law partner, met in 2005. And in 2008, we decided to start a firm together. We had no idea what we were going to practice. So we said, hey, let's just print out, let's go to dinner. We printed out a list of all of the areas of law. And then we went over it and we were like, okay, what will feed our souls? What are we interested in? And we ended with estate planning because we could make a serious impact in people's lives and have lifelong relationships, and it didn't require court. And then the natural ending of estate planning is elder law. And since I've cared for 7 family members and I just love old people in general, then elder law was that next part. So that's kind of our beginning. So what's great about learning from the ground up, because we knew nothing about estate planning or elder law back in 2005 and 2008, is that we can teach from the ground up. And I think there's so much misinformation out there about estate planning and elder law, and people go to Google University and they try to figure things out, and it's just difficult, to say the least. And there's a lot of misinformation, as I said. So that can lead people down the wrong path. So, so anyway, that's my introduction, and that's why we do this, and we do it differently than other people, I think. So, so here we go. First, thank you to Monica. I hear, not only do I know Monica, and so I know how wonderful she is, but I hear from so many people in your groups over the years how wonderful you are. So thank you so much for being wonderful and for doing what you do. So today we're going to talk about estate planning and some fatal flaws. We'll talk about elder law as well, and just kind of an overview of what that is and what elder law lawyers do. And then, of course, lots of checklists in this presentation. Everyone will get a copy of it, so you don't have to write down every single thing. If you want to take pictures of, the screens as they come up on your computer, feel free, but you will get the presentation as well. And then, we're here as a resource always. So the first part I always say to everyone is to put your own oxygen mask on. We, as caregivers, we always focus on other people first, and it's important that your own estate planning be handled. So I'm going to talk about estate planning from the perspective of you, and then the person you're caring for, that will be the elder law side. But of course, everyone over 18 needs some level of planning. So, so this applies to pretty much everyone you know. So the purpose of an estate plan, it's a bunch of documents put together, and the purpose of an estate plan is to honor your wishes, avoid court, and maintain family harmony. Now, I think that sounds pretty logical, right? It's something that I've kind of made up over the years, but it should be the definition for every lawyer practicing this area of law. And unfortunately, it's not, because almost every plan we see has a fatal flaw in one of these areas, and the client is usually unaware of it, which is sad and frustrating. And I'm constantly apologizing for colleagues whom I don't even know for not being thorough enough, not teaching enough. Education is really important in this area, and collaboration and getting to the nuances and details and layers. So what is estate planning, and what are these documents that I mentioned? So the first one, and the most important one, hands down, is the Advanced Healthcare Directive. If you are unable to make decisions for yourself, and you are asking someone you know and probably love to stand in your shoes to make decisions, your documents better state some of your wishes. They better give guidelines, because this is a huge responsibility and a huge burden. And the closer that advanced healthcare agent is to you, the more important I think it is. And from an emotional place, because a lot of people will second guess themselves, will wonder and question if they made the right decision, because there are no instructions in these documents that are sufficient typically. If it's someone you don't know as well, more distant to you, then they might not be as emotionally impacted by questioning whether they're making the right decisions. But it certainly is a big burden to ask someone not quite as well to make these decisions without a lot of instructions and details. So the Advanced Directive by far is the most important document to me. The power of attorney is for legal and financial decisions. So both of this side is if you're incapacitated and someone needs to step into your shoes. Now, once you're 18, no one can make these decisions for you. So every 18-year-old needs the Advanced Directive and power of attorney. On the trust and will side, you really only need those as you start having assets or having kids, right? We don't want your estate to go through probate. So if you have assets that would trigger probate, then you need more than a will, because all wills go through probate in every state. In California, our probate system is the worst because it's super expensive and it takes forever. So, and remember, if you have property in other states, this is not normal, but I just got a text this morning from my paralegal, Michelle, that I have a client meeting tomorrow with a couple, and they have 19 properties. Now, that's not normal for our clientele, 19 properties, but they have 19 properties. So I don't know what states they're in, but if you don't have a trust and you haven't properly funded that trust, meaning we've retitled the assets into the trust, you're going to, let's pretend there are 5 different states. You're going to have a probate in each of those states along the way. So having a trust and having it properly funded, which I'll go into more detail later, is a big deal. So a lot of people will say, oh, I don't need to do an estate plan. My family will just handle things automatically. They will potentially, but it'll be in court most likely. And who wants to deal with the court system? I don't. That was my deal with Din, my law partner. I don't go to court, and she doesn't run the firm or do networking meetings or do presentations, right? Like, we have a clear division of labor, and everything she does, she loves, and I hate, and everything I do, I love, and she hates. So court is awful. All right. So I have a question for everybody, and just bear with me for a minute because I have to scroll up and down in a live audience, of participants. I get to see hands going up. So this takes a moment longer. How many people, based on the definition I have with these main 4 documents, how many people have an estate plan right now? And just keep your hand up so I can see. I'm just scrolling through. There's some people who don't want to show their face. So hold on, I got to go back to the top. Keep your hand up. Keep your hand up. Good. Okay. Now, how many of you who have them have updated them in the last few years? Good. There's some other hands up. I love it. So this is when you can sign off because you're all up to date. Just kidding. You will still learn stuff. I promise, promise, promise. And if not, I want you to tell me at the end, oh my God, I knew all of this, and then we might want to hire you. So if you be honest with how much you have learned and not learned. All right. So the problem that we come into all the time, people call us, every day, is that they don't have a plan when they need it, or the plan isn't working as they expected when they need it. And so these are the common issues that we see among plans that come to us. So for those of you who raised your hand, pay special, close attention. So 1, we see outdated documents. So for everybody who raised their hand that you recently did it, that's great because then they're not outdated. We see missing documents. So be sure when you, look in your binder or however they came, if it's digital, that you have all of the necessary documents. So the ones that I listed are the advance directive, the power of attorney, the trust, and the will. But you also need a HIPAA waiver, and you also need assignment of personal property, which means you're assigning all your personal property to the trust. And if you have real estate, the deed has to show, when you look at it, it has to say it went from the seller's name to your name as trustee of the trust, or if it was done afterwards, your name, and then you transferred it into the trust. That's how we know what's in the trust, right? When this part where I say the trust is not funded, people look at the last page of their trust and they see a Schedule A or Schedule A, B, or C, depending upon if you're married or not and have separate property or not. That doesn't mean diddly squat. All that means is that this is a list of your assets. It doesn't mean that it's in the trust. So Din and I don't even do schedules because it leads clients to believe that those things are in the trust when in fact they're not. So what you have to do is you have to look at the actual deeds. Does the deed say it's in the trust? You have to look at your accounts when you get statements mailed and the faceplate. Does it say the name of your trust with you as trustee, or does it say your name as an individual? If you have a business, did you, and it's a corporation or LLC, or a partnership, but not a sole proprietorship. Did we assign, as the lawyer, right? Did we assign that business to the trust? So this funding the trust is really important, but it also goes with the missing documents because you want to see all of those things in your binder. Okay, we see a lot of confusing documents, a lot of really poorly written documents where it's confusing on what do they mean? right? If you have amendments, so if you have a trust, that it's a thick document, then you say, oh, I want to make a change. The lawyer either does an amendment where they say, okay, you have to still have this main trust document that you had, and then you have to have this extra, 2 or 3 pages of an amendment where we just tweaked certain provisions. Or you get a restatement, which is the new trust, same name, so it didn't mess up any of your funding, but it's a new trust that's your restatement. That's clean, right? If you have a whole bunch of different amendments, they will probably screw up your trust administration, because we have a client right now where mom and dad were married, dad died. The trust said when the first spouse dies, there's a mandatory split that has to happen. No client thinks their estate plan says this, right? But lawyers make this assumption. They do this A-B split when it's a couple. And then the kids agreed afterwards with the mom, hey, we're going to ignore that. So they did a whole document saying, we all have read it. We all understand the consequences of not doing it. We sign off on it. The next lawyer who got involved amended or restated, I can't remember, the original, and ignored the middle part of, hey, we're ignoring this A-B split. So now the next document and then the future amendments, it goes back to the A-B split, which is not what the client expected, right? So there's been adjustments in who gets what along the way, and it's a mess. It will not work according to it. So you have to be very careful with amendments. We as a policy will only do 2 amendments at our firm because we don't want that mess to happen. And we've seen it all along. Like, it happens all the time. Din has a court case right now where the end result of this mess of all these amendments is that the only son, who is a heroin addict, homeless man in his 60s, is going to get $6 million outright when his mom dies. That is not what she ever thought was going to happen. But then she lost capacity. So then we couldn't do it without court. So now it's within the court system. We have to get approval to create something different. Okay, so I could give you tons and tons of horror stories, but trust me, you want to make sure you have all the documents. And the part that's going to be hard for you, which I realize is not fair to say, is, they have to be drafted well. I get it that that's a little hard for you to figure out. Whatever you do personally and professionally, I'm sure I wouldn't know how to do it either. You want to make sure that the trust is funded, right? That we talked about that all the assets, don't forget about what that schedule says. That doesn't mean anything. You want to make sure everything goes in the trust that should. You want to make sure you have the right people, right? These are jobs that are tough. Not everybody is suited for them. If you have somebody, for example, as a power of attorney who doesn't pay his or her own bills, or who is financially strapped on his or her own, they should not be your power of attorney. It's too tempting to have access to money. It's a mistake. If you have somebody in your advanced directive role who is not very good around doctors and thinks they're God, no, because you got to stand up and advocate for your loved one, right? You got to question, you got to get second opinions, you got to do trials, whatever the situation is, right? So you have to pick the right people. If you have co-agency, meaning you have 2 people together as fiduciaries in any of your documents, you need to seriously consider whether that's a good idea or not. I say no for everything other than healthcare. But if you have 2 people working together in your healthcare directive, you better have a mechanism in the advanced directive to say, hey, if they disagree, what happens? Whose opinion supersedes whom? Who's the tiebreaker? Do we bring in whatever the solution is? We can be really creative. But there are financial institutions out there, big ones, who will not accept co-agents as trustees and will not accept co-agents as powers of attorney. So it's important to revisit that. Some people try to do these documents on their own. They go to the internet, they, get documents from, Office Depot or whatever. I don't recommend that. There's a lot of pitfalls in that kind of planning. All right. Any questions so far? Just pipe up
I
if you.
do. I
Yes,
have a question.
Elaine. I'm
Hi. Recently, someone said this to me, and I think it's the answer is false, but you're a legal person. Is it required by California law that you must have a will?
No.
Okay, that was what I said. And somebody on talk radio was telling people that this is necessary, and I was told I was going to be in a lot of trouble. So, because my
Trouble in
husband, well, my husband recently died, without a will, and so I was told I was going to have a lot of problems, and I said, it's not a law. I don't have, he didn't have to have one, and she
No,
was
but
like, oh, yes, it is, So,
100% it is not a law.
okay, that's
But I would say that depending upon the situation, depending upon your assets and how they're held, and depending upon if it's blended family, separate property, community property, all these other variables, not having something written down can make it more complicated, but there's no law that requires you to have one.
okay. Thank you.
Absolutely. Nobody's ever asked me that question before. Any other questions?
Yeah, Susan, go ahead.
Susan.
You're muted, Susan. You have to unmute first. Sorry.
There we go.
Hi,
We
Susan.
good? Okay.
Yes.
Are there a lot of the documents that we do that are good in multiple states, or do we have to kind of do the same thing over and over again if we make a permanent move?
That's a good question. And I do get that one a lot because so many people, at least in California, are moving out during the pandemic, right? I will say it depends, which is a classic law school answer that doesn't help you at all. But advanced directives in California, advanced directives in most states will work. Massachusetts will not acknowledge an advanced directive, and you must have a healthcare proxy instead. So there are nuances in different states that you have to be aware of. California does not have any inheritance tax, but there are about 10 to 15 states that still do. So if you get a trust drafted by an attorney in a state where there's no inheritance tax, and then you move to a state where there is, you need to do some planning for estate tax, because we didn't do that here. There are a couple of, I'm sure there are lots of different nuances in different states. I don't know all of them. The power of attorney here has a default if it says that you, if it doesn't say when it's effective and it's just silent, then you need 2 doctors to deem you incapacitated in order for it to be valid. It also, if you in California, if you want to have the power to gift, meaning you want to help support someone, you've been doing it all along, while you're incapacitated, that has to be specifically enumerated in the document. Not every state requires it. So there's a handful of things that I know of right off the top of my head that are different. So what we say is, if we do the estate plan, we'll try to connect you with a lawyer in another state if you move there, just to say, hey, we got some weird laws here we need to address and make sure you have, right? Did that answer your question, Susan?
It did. Thank you.
Okay. All right. Anything else before we move on?
Jeremy and then Vicky.
Yes, Jeremy.
I'm wondering, should if you have a restated trust, should the old trust be stored next to the restated trust, or will that just confuse things?
You don't need to. One of the beauties of having a restated trust is that we ignore whatever happened before.
Okay,
So
good.
you don't need to.
But you don't have to then enter all of the goods, so to speak. You don't have to.
No, but I would double check and just make sure your funding is still what you think it is. You know, a lot of these financial institutions have merged or been bought out, right? So like Schwab and TD Ameritrade. Do you think every single Benny form got transferred from TD Ameritrade to Schwab? I guarantee some got lost from gazillions of years ago, right? So this is the time to just, when you do a restatement, to revisit. You know, we have asset lists for every single one of our clients, and in our maintenance meetings, we do this, but if we were doing a restatement, We would look at every single asset and verify. And we verify the funding because clients will tell us, oh yeah, and then it isn't. And then we kick ourselves. So we like
Yeah.
to see statements for everything.
I bet that is important. And are IRAs also, do they have to be in the trusts, or are they just have beneficiaries? Yeah.
Right. They have beneficiaries. They're not retitled to the trust, but the beneficiary can be the trust.
Okay, good.
Yeah.
Thank you.
All right. I think Monica.
Yeah, Vicky, go ahead.
I'm sorry, can you hear me?
Yeah.
Okay. I know you touched a little bit on the Advanced Healthcare Directive, and I don't know if you're going to go through it a little bit further down, but
go ahead, ask your question.
POLST is a different document than an Advanced Healthcare Directive that I've been given every time I go to Kaiser with my parents. And the way you answer it is different. There, yeah, a POLST. Yeah. Okay, great. Then I'll be quiet. Thanks.
Okay. I'm going to tell you exactly
how to fill it out.
I went to become a pulse trainer, so I guess I could
Excellent. Thanks.
How to fill it out. Yeah, I'll talk about it for sure. Thank you. All right. So the solution for all of these things that will go wrong is just finding the right firm for you that will educate you, empower you, collaborate with you to create a plan that is really robust and will work when you need it. And also you have to have this lifelong relationship, right? So people ask me all the time in these presentations, like, how do I pick a firm? And my first two things that I would ask another firm is like, how do you educate us, right? And do you have a lifelong relationship? Is it like a transaction? How do you see it? Because this area of law is a transactional area of law versus court, right? Those are the two categories. There's no category for lifelong. It's like in the medical world, they have an oath that all the doctors take that we will save lives, but they don't insert the word quality in there, right? It's not quality of life. It's just how many years you're going to live. So I think this lifelong relationship part is really important in estate planning and elder law. Okay. So if you become incapacitated, an advance directive is really important, as I've mentioned. We go through all of these things with each of our clients. I don't have time to spend an hour just on the advance directive with you. But what I will say is that what we find often in these documents as we review them is the people have picked the wrong people. These are the common fatal flaws. Where that person, my test to be like, okay, can you go on that advance directive as an agent is, will you put your own wishes aside to honor mine? Are you local, or will you become local to take care of me and advocate for, at least for a period of time, right? And will you zealously advocate for me? Will you stand up to doctors? Will you make sure that those, whatever, nurses, CNAs, whomever who are treating me badly will never enter my room again? Will you be the one who is really there in that capacity? So if you don't have the right people in that role, it's important to revisit. Springing powers means that you need to be deemed incapacitated in order for it to work. We don't want that. We want it seamless. We want it instant. You get in an accident, you have a stroke, you have whatever, your person can seamlessly step in. There are no issues. Or with dementia, where there's a big gray area, but it's not like one day you have capacity and the next day you don't. So it's important that whenever it's appropriate to step in, you can do that without having to deem you incapacitated. We are finding more and more that these doctors will not sign the capacity declarations that we need. And if you have Kaiser, it's pretty certain they will not sign anything legal from us. Which means that you have to go to a geriatric psychologist or psychiatrist and spend a few $1,000s or more. The person goes through like 6 hours of testing. I honestly feel like on my sleep deprived days, I would fail that testing. I would be scared to go in and get tested, right? So it's miserable. And the solution is so easy. Make your advance directive immediately effective. And yet all these lawyers out there, they're still springing. And I try to teach them, and some listen and some don't. The other thing that's really important is to have a HIPAA waiver, and the CMIA is the California version, right? You need to be able, as the agent, to receive information from the doctors and nurses, from the medical community. If you don't have a HIPAA waiver, which the last time I looked, the California Medical Association Form Advance Directive did not have a HIPAA waiver. Is that unbelievable to you? Because it's unbelievable to me. So you've got to make sure you have these HIPAA waivers. We see in every single one there are insufficient details. That's just because everybody thinks of this document as ancillary. So having cared for so many people, and my mom's a doctor, you know, the two of us have been this team, and my husband's like the bulldog. So I guess the three of us have been this team to help people. It's really important to have a lot of details. And then there's no post. So Vicki, this is, you know, perfect segue into your question. If you feel on behalf of someone else or for yourself that resuscitation is inappropriate because the chances of success would be minimal, and or if you're really elderly, they're going to break all your ribs when they do it. So let's step back for a second, because people often don't know what this means. If you die, you have no heartbeat, you have no breath, no pulse. The default without this pink piece of paper signed by the doctor is that any first responder at the scene of anything or in your home or any team at the hospital will perform CPR to resuscitate you. If you are older and frail, they will break your ribs in doing that. So if you're in your 80s and 90s and you're kind of an older 80s and 90s, there are plenty of 80 and 90s who are like spry and amazing, right? I'm not saying that. Then everyone needs a pulse, and everyone needs to say, do not resuscitate, because the trauma and the trauma is great and the chance of success is minimal. So we have a video on our website of a doctor in Virginia saying that in a nursing home environment, and so we all know what that means. And so you could be in your 70s or you could be in your 90s. It's less than 2% chance of bringing you back. And it's 100% chance they're going to break your ribs. So that's the pulse. Okay. So now let's talk about how you fill it out. You say, do not resuscitate. And then you have to choose between selective and comfort. Comfort is the equivalent of hospice, even if hospice hasn't been ordered. Selective is, God, my mouse is moving so fast. Selective means that you can use medical treatment, including IV antibiotics and IV fluids. It says do not intubate. I feel like if you wanted to be intubated, right? A lot of people at this stage don't, which is why it's on there. But if you want to be intubated, you could talk to your doctor and you could cross that out, right? But comfort is literally no intervention other than keeping me comfortable. So morphine, you know, anything that will alleviate pain, and, you know, the suctioning, because that's uncomfortable. The rest is pretty self-explanatory, but those things, and the doctor needs to sign it and you need to have it posted. I have had many people say that in communities, they say it's a HIPAA violation. I don't know if you guys are comfortable with me swearing, but if it was unanimous that I could swear, you know what I was saying. That's ridiculous. It's not a HIPAA violation. It's me putting it up there. It's my advance directive agent putting it up there so you honor my wishes, right? So the idea is this gets posted in the house. I was meeting with a client Monday, and she said, but it's a hot pink piece of paper, and I have a really beautiful condo. I don't want to put that thing up. And I'm like, you want to be resuscitated, or you want to care? And she was like, okay, I'm going to frame it and I'm going to put nice things around it. So you can do whatever you want. And I said, if you want to know exactly where your fire department, where your paramedics are going to look, every fire station has 3 shifts, A, B, and C. Call your local fire station and say, I want to talk to the paramedic. Where are you looking for that pulse? I used to drive around because I did a lot of volunteer work with firefighters. I used to drive around when Pulse first came out. And whenever I would see a fire station, I would stop and I'd be like, hey, I just want to talk to your paramedic. And they're like, what? And I would say, hey, do you know about the Pulse? And at the time they would all say the what? They didn't know anything about it. And then I'd say, okay, now that you know what it is, where would you look for it? And all the paramedics, firefighters who were over 50 said, well, duh, I'm looking on the refrigerator. And every one of them who was under 50 said, why the hell am I going to the refrigerator? Right? So you want to ask where they look for it because you want it honored. That's the whole idea. Vicki, did that answer your question or do you have other questions?
It did. When when I had spoken to somebody, my parents both have like the do not resuscitate and all that stuff in their actual advanced healthcare directive. But when I talked to the nurse on filling it out, the pulse, she had me actually select like the opposite of those things, just because it was for what she said, first responders, and not necessarily like a decision that he needs to make right then and there. Like, is he that ill? Is he this? Is he that or that or the other? So she actually, I think, had me take use the selective, I think, to check that. And then also for the like feeding and whatever, that too. So
Tell me, so choosing selective is
Mhm.
still saying do not resuscitate. So that's okay. And this is the only document in an estate plan that you can fill out for someone else, right? Once you lose capacity, you can't create any of these documents, but you can create a pulse. So right now, if you would say, hey, if my parent got a UTI, I want them to get, and they would want to get IV antibiotics, it has to be selective. But at the
Right.
point where you say, no, that's his or her way out with pneumonia or whatever, then
Mhm.
you rip that one up and you do a comfort one and you get the doctor to sign it.
Okay. Okay.
Does that help?
Yeah, it does.
Okay.
Thanks.
Okay. I
And
see
Rebecca,
that.
I see that Bren has their hand up.
Hi, Bren.
I was told that one should have a pulse in one's glove compartment of their car. Is that true?
You know, I think it doesn't hurt. I think for however strongly you feel about, I do not want to be resuscitated no matter what, you would have one at home and you would have one in your car. Whether they look in there and can get in there is another story, right? In older cars, hell yeah, you just open it. In my car, you have to like push all these, there's no button on the glove box. You have to like figure it out. So I just don't know how realistic, maybe like the console in a newer car, right? They might look in there first.
Okay.
This would be now, Bren, now I'm gonna have to drive around the fire departments again and say, okay, when it's a new car, where do you look for the pulse? It's a really good question.
Also, my pulse is very old and it's green. My husband's, however, is pink. Does
Yours
that
is from
matter?
another state?
No, it's California.
I would do a new one because
Okay.
I've been following Pulse from the very beginning, and I've never New York has a green or a blue one, other states, but as far as I know, ours has always been pink. So I feel like somebody printed it on the wrong color paper is all.
Okay. It's on my fridge and there's a green one and a pink one. Mine is green, my husband's is pink.
If it's okay, I would do a pink one, right? Like the next
Okay.
time you're at the doctor, and they did change them. They've had 2 modifications to them. So just make sure that you print out a new one or that the doctor just gives you a new one.
Okay.
I think it's worthwhile. You don't want the paramedics being like, wait, this is green. You know, you want like fast decisions. Elaine.
Okay, I have a pulse. I don't know where it is. I know the hospital that I usually go to, I know they have it because I've had many surgeries. But in hindsight, I might have it here somewhere, but I think I had to give them the pink copy. So I'm trying to figure out, how do I get a copy of that to make sure it reads correctly as I want it, and also to be able to have it here at home in case there's an emergency here.
I would just have them fill out a new one
Okay.
and take the copy for the hospital. They don't need the original. You need the original. So the idea is that you have the original. When you go to the hospital, you bring it. When you go to rehab, you bring it. When you go back home, you bring it, right? And it follows you around. So anyone can have a copy, but you should always have the original. But I know I don't know your age or your medical history, but are you sure you want a DNR, a do not resuscitate? You seem young for that.
Oh, I wasn't saying that, that part at all. Probably would, probably would want to do not resuscitate, but I'm just concerned that I don't have anything here
Right.
to direct them
Okay.
in case there's an emergency
You
here.
definitely want it there at home.
Right.
Okay.
Terry, were you raising your hand? Yeah, go ahead, Terry, and then Jeremy.
Okay, I had a question here. Besides having it posted in your home, is there something you can put on your iPhone under like health and just have it loaded there?
I think it's a great idea. And if you know anyone in their 20s who wants to develop an app and sell it, it would be great. But I don't think anyone is going to look there yet. Right. I think it's like we have this emergency thing on our, I'm kind of a Luddite. So I don't know how to use, like, there's this whole emergency thing. How do I get to that thing fast? I don't know how to get to that thing fast. Right. So,
yeah.
so
I would think at a paramedic, they could look at your health, your phone, and it unlocks it, right? So in an emergency.
how do they unlock it?
An SOS, pop up and see if you have like factor 5 or any medical conditions would pop up there.
All right, I'm checking it out right now.
So, and also, is there something on my chart? Can you put that the post on the my chart?
You can put it wherever you want, but they need it physically posted where you
So
are.
they need it. Okay.
Yeah.
I'm just worried that I won't be home when something like that happens. You know what I mean? It's fine if you're home. Hopefully they'll find that tool, but.
Yeah, no, I hear you. All right, I'm going to check it out on my phone after I'm done.
Okay, I will. Okay, thank you.
Yeah.
Great, Jeremy, and then we'll move on here. Yeah.
Yeah, the same idea. There's got to be some central place where you can keep all this stuff, because it's madness to think that that in a given instance it's going to be right there and handy and quick and all that.
But I want you all to keep in mind one thing. Everyone on this Zoom, it's arguable whether any of you really should have a post. Arguable. A post is designed for the last year of your life. That was the original intent. When you are in the last year of your life, when it's planned, right? Like if you have a heart attack, who knows, right? But when you have something that's debilitating, you're mostly at home or you're in a community and you're kind of there a lot. You're not out driving and all of that. So that's why being posted is relatively easy. You guys are asking important questions, but there are a lot of doctors who wouldn't sign off on a post for you because you don't qualify yet.
Yep.
Okay. Monica has to keep us moving forward because she knows I have so much to talk about. All right. So fatal flaws with the power of attorney. So we're done with the advance directive for now. We're moving on to you're incapacitated and you need someone to handle your finances and handle anything legal on your behalf. The thing we see all the time are the wrong agents, just like the same as I described with the power of attorney, with the advance directive. So for power of attorney, my list is you have to be financially independent. You have to pay your own bills on time, open your mail, be good with insurance. This is the worst job ever. Like, I know I'm listed on my parents, but God help me when that time comes. I hate doing this even for myself, right? So there's just all the paperwork. Imagine there was no email anymore. All the paperwork that got mailed to you way back when, that's what the power of attorney has to deal with. Paying the bills, dealing with taxes, dealing with the, Social Security, all that crap. All right. We also want to, so you have to pick the right people. I would recommend, if you have co-agents, get rid of that, have one and then the other, because Chase doesn't like it. Bank of America doesn't like it. Wells Fargo is okay with it. USAA doesn't like it. They're just increasingly not wanting, for liability reasons, to deal with two people in these powers. Springing power is the exact same concept. We want this immediately effective, but unlike the advanced directive, where your agent needs it now in case something happens, I don't give these out. Even for our clients, when they come to us and they say, do I give this to my kid, whatever, I say, no, you introduce them to me and I will be the determinant of who gets it and who doesn't, because I want to make sure they get it. The right person gets it. It's not being circulated, because with an advanced directive, imagine you're totally fine and your agent, your adult kid, comes in, and like, the doctor's not going to listen to that adult kid or friend or sister other than you. But you take this power of attorney to a bank and you say, I'm the power of attorney, and this can happen without you even knowing it. So you need to, A, make sure you're picking someone you absolutely trust, and B, don't give it out. Also, you might amend it, right? And then you have old documents floating around. Okay. It's important that if you want to be able, your agent, to give gifts to help support someone, charities, people, whatever, that you specify that in your document. This is blank a lot of the time. So when we had to do Medi-Cal planning before the rules are now about to change, we couldn't do it, because once you lose capacity, you can't change this. And there was no gifting. We couldn't get some people eligible for Medi-Cal. You want to have access to separate property. Separate property is everything we bring to the marriage and everything we inherit during the marriage. If the well spouse needs to access that separate property to pay the mortgage or do anything that benefits the well spouse too, you cannot access that money unless your power of attorney says you can. These are specific, maybe to California, maybe other states. I want to make sure that everyone has it on their list to organize all their logins, all their passwords, and a list of all their bills that you pay, when they get paid, where they get paid from, auto this and auto that. And then when somebody loses capacity, and always in a trust administration, those accounts get consolidated and closed. And we have no idea that insurance needed to be paid. Right? And then it lapses. And then remember that every time you need to use this, each financial institution has their own power of attorney. So while you get one created by the attorney, and you can have a statutory one as well, we always do both for a couple different reasons, then each financial institution has their own. So the easiest thing to do is, while your loved one is okay, go to the bank. They fill it out. You don't even use this. They fill it out and say, I want so-and-so to be my power of attorney. Otherwise, you have to send the attorney drafted power of attorney to the bank. They have to send it to legal. They're going to mess around for weeks. You're going to follow up 72 times, and you're going to want to pull your hair out, right? That's just the way it works. And there's nothing, and you're going to get misinformation right and left. It's a total pain in the ass, but it's the only way that it works. All right. So what happens if you pass away? Any questions before we move away from incapacity? And now we're just talking about death. I'm going into so much more detail than I usually do, but I think it's helpful for you. Kathy.
I'm not sure if you can hear me. Can you hear me?
Yes.
Okay. And I had to step away for a minute, so I don't know if you covered this already, but will you be talking about irrevocable trusts and when those are appropriate and the differences between?
I will mention it right now briefly because I don't talk about it. So 99% of our clients have revocable trusts. every revocable trust, meaning you can change it during your life while you have capacity. Every revocable trust becomes irrevocable when you lose capacity and or when you die. Irrevocable trusts are created for tax planning purposes. You need over 12.92 million right now to trigger a federal estate tax. So most of our clients are not in a taxable bracket. In 2026, right now we're still in the Trump law. In 2026, we're going back to the Obama law. It will go down to about 6.8 million that will trigger a 40% estate tax over that 6.8 million, and it will creep up every year. So irrevocable trusts are also done when in a couple other scenarios, but I don't want to spend too much time on it. Did you have a particular question that I could answer about it?
Yeah, and it was related to more on the side of like Medicaid planning, I think.
So Medi-Cal planning, we don't do Medicaid in California, and I don't know anything about it.
Medi-Cal, sorry. Yeah.
That's okay. Medi-Cal planning, you do not need to do an irrevocable trust anymore. That law changed, I think, in 2017. So just erase that from your mind.
Oh, that is good to know. Okay.
Yeah. And
Thank
lots
you.
of lawyers out there, you might have realized I'm a little critical of these colleagues. I don't know, but lots of lawyers out there are trying to, I think, scam people. And they're like,
I think
Medi-Cal asset protect. It's bullshit.
yeah, that's where I'm currently at, and I was very suspicious, so that's why I wanted to ask you the question.
Be suspicious. And the laws are changing in January. We're in mid-November. Oh, it's my best friend's birthday today. We're in mid-November. I just remember it's November 15th. We're my childhood best friend, not Din, my best friend. We're almost going to have this new law take effect. So I tell people who are calling about Medi-Cal planning right now, don't do anything. Let's see how this plays out.
Okay,
So
that was going to be my next question.
Right now for Medi-Cal planning is suspicious. Okay.
I appreciate it. Thanks.
Of course. All right. So what happens if you pass away? You know, people assume everyone's going to get along. Nobody's going to care. It's not true. People come out of the woodwork. They care about money. Even these people in the cartoon have weapons, right? There's just nastiness happens. So if you have under $184,500 and no real estate and no minor kids, right? No young adult kids even, and you're okay with giving it outright, a will suffice. If you have real estate or businesses, you want to sprinkle things over time, you have special needs folks, you have spendthrifts, you have kids and grandkids, you want to trust, right? So a will can work for people who have very little, and they're okay with people getting it outright, but it's important to know. All right, so this slide alone, I could spend so much time on, but I'm not going to today because Monica's going to be like, hello, we're out of time. But it's really important that every single person, you know, either take a picture of this or go back to it when you review this. So this is slide number 17, or that's what it says on my little thing here. When an asset is in your trust, it means that it has been retitled, right? It's not just in the schedules. We talked about that. These things, all these assets that are in the trust go through the trust in the trust administration. The person who has power over those assets is to control them, to use them, to access them is only the trustee. So if someone is incapacitated, you need to resign them as trustee in order to access them. So it's sort of a double-edged sword because people want access now. They don't want to have to get somebody deemed incapacitated, right? We talked about how hard that is. But at the same time, you want it to go through the trust administration, right? So we look at every single family situation uniquely to figure this out. If the asset is in my name or your name, then your power of attorney has access, not your trustee. People get this all mixed up all the time. And a lot of people think, oh, the advance directive is in my trust, right? Like these are all totally separate documents doing different things. So if the power of attorney is the hat that you're wearing to do this, it could be the same person as your trust successor trustee, right? Then is it immediate or springing powers? We want them immediate, right? And we want to make sure it's the right person. We need to make sure that you have authority at these different financial institutions. And if it's in my name, you need to make sure there's a beneficiary designation, because without that beneficiary designation, it's not going anywhere. Now, here's where people get all screwed up. I feel like this is a commercial for something. But wait, there's more, right? If the asset, so many people add their adult kid or their sibling to the account, to the deed. They do this with the intent of, I want to make it easy for them to make decisions and help me. But what they don't realize is they just gave that gift to that person, because when that person, the principal dies, that asset goes immediately, with some paperwork, immediately to the co-owner. It bypasses the trust administration completely. This has pulled siblings apart. This is not what the parent expects 90% of the time. Sometimes the parent does expect that, and the parent says, hey, this one kid does everything for me and the other kids don't, and so I want this asset to go to this kid. That's fine. But if that's not what is going to happen, it's a disaster to add someone to the account. That's when you use the power of attorney. Okay. Any questions about this? Okay. Moving on. Super important. So what is probate? Probate is you have a will or you have no will. You have over 184,500. You don't have beneficiaries or transfer on deaths on those accounts or assets of 184,000. If you have other assets and they have beneficiary designations, it's not a probatable asset, so it doesn't go into this equation. Then you're headed to probate. They have to find an original will. The judge has to say it's a valid will. If not, it follows the law of intestacy, which is not anything anyone has any control over. It's just next of kin. So it could be the sister you never talk to is getting everything. It's a mess. The executor might be the person named or not, depends. They have to get a bond. It's a whole thing. It's super expensive. I'm going to show you a slide. Assets are frozen for months. So while a surviving spouse or, a kid who lives in the house or whatever is needing to access it, all the assets are frozen for months. Creditors are notified. So it's a public process. It takes a year or two to get through. Total disaster, 100% avoidable. There aren't things that I can say 100% about, but this I can say 100% about. All right, so this is what it costs. If your estate, let's just say, is $800,000, including your house, you do not get to subtract the value of your mortgage to get the number in column 1. Then you are minimum paying $38,000 in probate fees. The lawyer gets half, the executor gets half. There could be additional fees on top of that, but that's the minimum. It's governed by statute, so it's not up for debate. If you have a trust, there are no probate fees, but it has to be funded properly. Otherwise, we could still end up in probate. All right, so to avoid probate, you get a well-written trust. You have the right trustees in there, and you fund it properly, right? So I always talk about planned giving, and I think it's super important to give back in our trusts. And so just always remember what this group has done for you in your own trust planning. Okay, so fatal flaws we see in trusts all the time. There are issues with the successor trustee, right? They can't do it. And I don't know if any of you are CPAs, but CPAs are the number one people, if they don't have adult kids they trust. CPAs are the number one people, professional that people go to for this. And they're the worst possible trustees because they have so many deadlines for their clients that this is on the back burner, right? They're not good trustees. You want the right trustees. You want to make sure your funding is complete, not incomplete. Again, your documents are clear. With that, marshal the assets. The slide I said is super important. You want to make sure the right people have access. We see financial elder abuse all the time. If you're married and your trust has an A-B split, I don't think you want that anymore. It means 2 levels of trust administration, way more expensive, invasive. You have to, for the person who died, they have an irrevocable trust. It gets its own tax ID number. It pays income tax. It's a pain in the butt. Most people don't want that. A lot of trusts don't have trust protectors. In all the new trusts that we create, I think mine, maybe a couple of them, people don't want them, and I say it's okay. But trust protector is a third-party neutral who is the judge over your trust. If anything goes wrong in the trust administration, the trust protector can handle it, and we never have to go to court. It's awesome. If you have animals, you better have someone in there to take care of them, and you better leave some money for them, because I'm a huge animal person. All right, Susan, I see you have your hand up. Wait, you're muted.
There we go. Sorry. Not quite sure where it would fit, but if you can just touch upon it somewhere. What about people who don't have the property or the accounts, but we're looking at retirement and pension being protected, or?
You mean where do those go in a trust?
And how to make sure that that's all.
The trust is just the beneficiary.
So you leave your, but you don't leave your pension. You can leave your.
If your pension has a beneficiary, right? If it can have a beneficiary, then you can see every pension's totally different. So I never know how to answer that 100%. Usually it has to be a person. But for a retirement account, it can always be the trust.
But these things that like have beneficiaries, do they also have to be included everywhere else? Because
So
they're already legally.
You either have a beneficiary or the trust is the owner, but you don't have both.
I mean, we don't have to put it anywhere. If you're already a beneficiary on something, then you wouldn't put it in the trust because it's separate.
Correct. But the trust could be the backup, right? So like say, and I'm just making this up, say this is your mom's, right? And she has 3 kids and she says, I want everything to go equally to my 3 kids from my IRA. If one kid passes away before her, then in that beneficiary form, it's likely that kid who died, her kids aren't getting anything and it's going to the other siblings. If she wants her kids to get it, the backup could be the trust, and then all the rules and all the layers and everything that we design in the trust would take over. So it just depends on each situation. Okay. All right, so trust administration. There are 2, I did this like fancy thing where I inserted a video. I got really creative with my Luddite skills. So I always say hire a lawyer to help with the trust administration, because there are some ways that the lawyer needs to protect you as trustee. Unless you are the trustee and sole beneficiary, then you don't need a lawyer. Right. But if there are any other beneficiaries and you are the trustee, it's really important that you hire a lawyer, that it get done right. You want the easy peasy route. You don't want the getting blood from a stone route. Right. And so when these things aren't set up correctly, when the funding isn't done correctly, we end up in court and it's a nightmare. Caregiver burnout is real. I don't need to elaborate on anything other than it's really important to take care of yourself too as a caregiver. So there's 6 immediate actions that I think each of you should take, right? Create a village of people who can help in this caregiving role and care for yourself as well. Finish or update your estate plan. Share your wishes of all these things that you want with the people in your family. Make sure you organize all of your assets and you fund your trust and the beneficiaries are up to date. Get that logins and passwords and bills list created, and make sure you're properly insured. There's a lot of people with their house insurance and their car insurance where it's inadequate. And those are devastating stories. So it's really important to make sure. I go into more details, but I'm going to run out of time. So make sure that you don't fall into this myth, right? Oh, my spouse or my kids are just going to be able to handle things automatically. We know that's not true. So here's the elder loss part. It is mostly therapy, and then a little bit of law. It's when people start needing consistent, permanent help that elder law is triggered. And it means that usually, sometimes the older person is having trouble, but more often it's the family members caring for them. And it's how do you navigate this whole world, right? And so elder law lawyers help with that. When you're overwhelmed, we help with that. When there's family drama, we help with that. When there's capacity issues, we help with that. And when someone's running out of money, we help with that. So conservatorship, you know, with Brittany, a lot of people now know about it. Before that, not so much. If you don't have an advance directive, you don't have a power of attorney, and you lose capacity, you're headed to conservatorship. It's a very expensive, permanent, invasive court process that should be a last resort. But here's the caveat. Even if you have an advance directive and power of attorney and you lose capacity and you refuse to let your agent help you, you have to go through conservatorship. You, as the advance directive or power of attorney agent, can't force someone against their will. You need a conservatorship to do that. So not a lot, sometimes with dementia, depending upon the type, people get very resistant and difficult. And so conservatorship is the end result anyway, unfortunately. And so the important thing is, like, do these documents now, right? Because once you lose capacity, you can't create them anymore. So the conservatorship issues it's just super expensive. You know, it's about $10,000 to start. You can either get a conservatorship over the estate, which is like the power of attorney, or over the person, which is like the advance directive. Sometimes people need both. Sometimes it's one or the other. There are families where they vie for this position. And so this is contested, but it's always contested, not always, often contested by the proposed conservatee. They don't want you to strip their powers, right? And so then there's a lot of tension between you and your mom or dad or uncle, aunt, whoever it is. So that's why it's always a last resort. So long-term care planning is private pay, right? It's super expensive. Those numbers are pretty accurate. Medicare does not cover this unless you have a hospital stay of 3 days, and then it covers up to 100 days after that, but only if you are making progress. So a lot of families fall into this trap thinking, oh, they're in the rehab for that long. Every week, those team leaders are occupational therapy, physical therapy, right? All of them are meeting to say, how is your person doing? They will give you hardly any notice. So if you have a loved one in one of those communities, I would say 100%, you need to know when that meeting happens. And the next day you need to follow up with them and the social worker, whomever you work with, and say, like, what was the result of that, right? I don't want you to spring it on me and say, oh, in 2 days you're discharging my loved one, or you have to privately pay. And that's what they do almost all of the time. So it's important to stay on top of that. So Medi-Cal is changing. Right now, you're allowed to have up to 130,000 as the applicant. It used to be for decades 2,000, but now you can have up to 130,000. The spouse can have 148, a little over 1,000. If it's 2 people applying, you can have almost 200,000. But in January, it's no longer based on assets. It's now going to be based on income. So the theory is that if you have low income, you probably have low assets. There are plenty of people who are real estate rich, right? And cash poor that have plenty of money if they got a reverse mortgage or they sold something, right? But those, I guess, to these decision makers are the exceptions to the rule. So it's now going to be not asset driven. You could conceivably have $10 million in real estate and be on Medi-Cal if you don't have very much income. All right. We don't really do much aid and attendance. benefits anymore, but there are benefits out there. They have a 3-year look back. And so once that law came into effect, a lot of people stopped doing it. So the problem is like this gray area when people have not enough capacity to be making good decisions, right? So they're making poor decisions, but they haven't lost enough to where a judge will grant a conservatorship. And this creates a lot of tension and a lot of drama in the family. And this is where we start with plan A and then maybe B, C, D, E, F. We just keep going until we figure out how to do this. And it's just having that elder law firm who can come up with these problem solving techniques. So for those who still have capacity to make decisions, like your loved ones, the 5 things they have to do: get 2 capacity declarations if possible. And the reason that I say this, while they have capacity, the doctors are much more likely to sign it. It's when they don't have capacity that they don't want to sign it, excluding Kaiser, who doesn't want to sign any of them. But the reason is because A, in order for us to update documents, you need to have capacity. But even more importantly, in the future, if they might need a reverse mortgage, the reverse mortgage companies are requiring 1 or 2 capacity declarations that were signed contemporaneously with the power of attorney. And if you don't have that, and you can't go back in time to get that from a doctor who may be retired or may be unwilling, you can't get the reverse mortgage. So it's really important to get these cap decks. Finish or update the estate plan the same. Make sure the advance directives and powers of attorney are immediate, and discuss this gifting authority. Now, I have to change the slide as of January, right? Because then that's not as critical. Maybe not, because maybe there's an income producing property or something that we would want to gift. So I just don't know how this is all going to be implemented yet. Oh, it shouldn't say Alzheimer's LA. It should say your group, but you guys kind of all are also amazing. Anyway, get in a support group. It is life-saving. A lot of people think they can just do it themselves online. We see a lot of disasters. My favorite disaster, and this sounds terrible, I shouldn't say it that way. The most stunning disaster, how about that, was somebody who went to LegalZoom. She created a trust. She did it with her friend because she needed help. The way it ended up in the end was the friend was the trustee, and the trust, however they did it, was funded, because LegalZoom doesn't teach you how to fund, but they funded the trust, and the friend was the lifetime beneficiary. So she ended up giving the friend her entire estate in this trust, right? It's just, you don't want to do that. Okay. So if you can't create these documents, right, because you don't have capacity, then you might need to go through conservatorship. And you can't update the documents, but you can, as we talked about earlier, you can create the post on behalf of someone. So that's really important. And marshal those assets. You can do a lot of that work. If your power of attorney has the authority to gift, and you realize that there's an asset that should have a beneficiary designation, but doesn't, and let's just say it's equal among the 3 kids, you can sign that beneficiary designation if the power of attorney has the authority to gift. If it doesn't, you can't. So there's a bunch of different ways this creeps up and why it's important. Oops, sorry. And then family harmony is really important to me. And so just whenever there's disharmony, if you can get people on the same page, that's really amazing to do, and just spend time together. Find your A-team, have them ready for whatever you need. You just know the right person to call, so you're not stressed out and trying to figure out who these people are. And then we're almost done. So there's a whole bunch of checklists in here, so you have those. And my favor to all of you is don't assume that family and friends are prepared and ready. Most people think they are, and then they aren't, or they're just not. It's been on their list forever. So you might be that 7th reminder that triggers them to take action, right? So just talk about it. You learn more today than almost everyone learns after spending all the time with a lawyer creating their own plan, because most lawyers don't talk about this stuff in enough detail. So we're here for questions and resources. Oh, and just remember, court sucks. I haven't shown this slide to Din, but oh, I just can't stand court. So this is just the gift that you're giving to the people you love. And my big 4 takeaways are: don't wait until it's too late. And remember, if you have any beneficiaries who are on Medi-Cal or SSI, they need special needs trust provisions in their trust, right? We're doing a trust administration right now, and one son has been is special needs and has been his whole life, and there were no special needs trust provisions, and so now he's going to inherit this money, and it's going to ruin his benefits, and then the sister is going to have to redo everything when he runs out of money. It's a pain in the butt. Court sucks. That's my big message. So you want to get this done. You have huge peace of mind. You can do it. And then this is the list. If anybody is interested in what to ask lawyers, right? This is the list to ask lawyers to see if they might be the right fit for you. All right, that was it. Any questions that people didn't ask already? You guys already had some good questions. No questions?
I have one.
Jeremy.
Just a quick question about Medi-Cal and the new stuff that's coming up in 2024. If in California, since it's a what's it called, a community state, do you have to file separate tax returns if you are trying to keep under those things, or there's a mutual amount that you can still qualify? One person can qualify for Medi-Cal on. Is there one amount?
The tax part is not relevant. And in January, you can have as much money as you want and qualify for Medi-Cal. So it isn't about how many assets you have or what the value is. It's just going to be based on income. So right now, if you are in a skilled nursing facility, they take all your income as the applicant. They take all your income and leave $35 for you to buy, like, what, 3 candy bars? I don't know. That $35 hasn't changed in a long time. If you're on in-home support services and your income is less than $1,564, you have no share of costs. If it's more than that, you have share of costs. So for in-home support services, because the max they give is 66 hours a week, it's often not, it doesn't make sense. If you have a larger income, you end up giving more away in your income than the benefit of in-home support services, right? So it doesn't really make sense to do that.
Right.
So there's so many numbers, and those numbers will change in January. I don't even know what they are yet. Sometimes they change in January, sometimes they change in April. So I don't know what those are in terms of like what the community spouse is allowed to have, right? But the community spouse, the non-applicant spouse, can have a little over $3,000 in income every month. They're not trying to impoverish the community spouse in doing that, but those numbers are all going to shift. So
is there a good way to get clarity on how this will apply to you and whether the numbers will work?
So Canner is a really amazing resource. It's CANHR. And I go there for all kinds of stuff, but let me go back to that slide. Oh my God, I don't know how to make it. Hold on. Where's the Medi-Cal slide? Give me a sec. I'm going back. Here it is. Okay. So I don't know if I wrote, I didn't write it down. I have this whole flow chart thing that's like in a PDF that's like 4 pages long. It is the most ridiculous, but I'm hoping in January I can simplify this. So I don't want to give it out now, but Canner is the best place to go. CNH. They have so much information. You can call them. Their website's amazing, and they update all of this all the time.
And I put their website in the chat as
Oh, thank
along
you
with
so much.
Rebecca's email
Fantastic.
and also phone number as well. So all that's in the chat right there.
Thank you,
Marissa,
Monica.
you have your hand up.
Hi, this is a pretty broad question. Do you know if you have assets in another country, can those assets be covered by a U.S. attorney, or would you need to get an attorney in another country, in that country?
You need to get an attorney in that country. Our documents and our court system has no jurisdiction for assets abroad.
Okay. Okay, so then you would have the two parts of your trust kind of dovetail into each other?
So depending upon what they are, what the assets are, and what the long-term intent, you could have it where it could funnel here, or you would just have two separate things. But taxes might be really great if they're going to come here. So that's why you have to figure out what the laws are in that country.
Okay, thank you.
Mm-hmm.
Elaine.
Hi. Do you know anything about unreimbursed costs of care? That a statement comes after somebody's been in a facility?
Do you mean when they've been on Medi-Cal, or you mean?
No Medi-Cal, regular Medicare.
I don't, but I have someone to ask.
That was going to be my next question.
I would ask, hold on. I'm getting up her name.
Okay, great.
Her name is Jeannie Reynolds, and her number is 818-707-3331.
3331.
And
her
ask
last name
her.
is Reynolds.
Yep. And Jeanne, Jeannie Reynolds.
Jan. Okay, great. Thank you very much.
You're welcome. Any other questions? Okay.
Yeah, Bren, go ahead.
Oh, sorry.
Haha. Oops, you are muted, so you have to unmute. That's all right.
If one
There you go.
already has a trust and we're worried that we may have one or more fatal flaws, is there a package fee or a flat fee to have that trust reviewed?
So we do that. We have a package that's $995 where we review it, and then we spend a couple hours talking through it, and also whatever updates you think you want to make. And then what I do say, I've been doing this more and more lately, is if it's a spouse, situation, we look at it first, at the trust first, to see if it's an A-B split. And if it's an A-B split, we bypass that altogether because we know we're going to do a restatement so that people don't have to pay that $995 to just learn that it is an A-B split. It didn't seem fair anymore. And so that's what we do now. If it's not an A-B split and everything does go to the survivor, then we continue with the plan. And then at the end of that plan, we know, hey, there's not very many changes to the trust, but you want to do a new advance directive or whatever, and then it's hourly. Or by the end of that, we realize there's so many changes, or the trust is so poorly written that then it's a new flat fee to do what's next. So those are always a little bit different because I don't know what the outcome will be yet.
Thank you.
Of course, of course. Any other questions that people have? I've probably talked way too long, but I hope you've learned a lot.
No, this is great, Rebecca. And again, we had it until 11:30, so you actually have 3 extra minutes. So we've got plenty of time here. No, and again, anyone, if you think of other questions, feel free to, reach out to Rebecca. I have to say she's usually my go-to if a question comes up in group and I can't answer it. I will shoot her an email and ask her for that help and support. Also, the recording of this will be sent to all of you since you registered and you have the link,
Right.
as well as for anyone who is unable to attend but who registered. So again, Rebecca, thank you so much for you give so much to all of our caregivers. And so we're very grateful to you, and thank you for your time. And thanks for making lots of this just understandable. That's why I like Rebecca. I just feel like it's like she speaks normal people. And I think we all appreciate that. So thank you so much.
Yes.
Absolutely. Absolutely. Well, thank you all. I know this is not the most pleasant topic. So it's nice that you're here and willing to learn. And for those of you who have plans already, did you learn something new?
Oh, yeah,
Excellent. Excellent. Very good.
for sure.
Well, thank you again. And if you have questions, reach out, and have a great Thanksgiving coming up and a holiday season, and have fun in the rain. I'm so excited.
It's
Thank you,
pouring here right
Rebecca.
now.
Oh, it is. Where are you?
I'm in Whittier and it's cats and dogs.
Oh, really?
Really?
Wow.
It's almost short of hail. Not
Oh,
quite, but
Wow.
that bad. That's why I keep looking away. I'm like, oh gosh, I hope I'm not being rude. But it's just like right in front of me as I sit here.
No, it's
So-
I get excited. I have horses, so it's always like a thing. We were preparing for the rain last night for a couple hours, but I love it when it rains.
I'm just hoping it rains hard enough to get like the good solid layer of pollen off all the cars. That's all I'm hoping. Like, let's just go for that first good rinse off. That's all that matters on for this storm.
Yeah.
All right, everyone, be well. Thank you so much for coming. Have a great
Thank
day.
you.
Bye. Thank
Thank you.
you.
Take care. Bye.